conversation at all. And second, that the information published was a matter of unusual public concern involving the threat of physical harm to people in the community. And on that basis, Stevens got his majority. Chief Justice Rehnquist dissented with Scalia and Thomas, and their argument has some plausibility. I don't know how you react to it. In their view, this decision diminishes rather than enhances the purposes of the First Amendment. It's that chilling effect on speech caused by the fear that what you're saying may be broadcast to the world. And the dissenters pointed out that this law about non-disclosure of cell phone conversation is content neutral, therefore it doesn't trigger strict scrutiny. It restricts only information that was illegally obtained. It didn't impose any special burdens on the news media. It applied even-handedly to everybody, unlike the Florida Star law that singled out the news media. This applies to everybody. And it promotes the privacy and speech of cell phone users. I don't know who you think's right in this battle. Kelly? I don't know why they use that word, unusual. No, I mean, it's like saying very or extremely, or, it's just an adjective. I think it's sufficient to say, as Stevens did, this is a matter of public concern. Here it's of unusual public concern because it's not just about the strike and strategy in the teacher strike, but it's a threat of harm to individual people. Maybe that makes it unusual, and therefore more justifiable to allow the disclosure of that information. Ron? That's what the union people were saying. We need to light fire under the porch and blow it up if they don't get on board on this thing. Is this case relevant to the WikiLeaks situation, if WikiLeaks is prosecuted for violation of the Espionage Act? No one? The WikiLeaks information is not of legitimate public concern? Well, you're talking about the State Department cables that show what our diplomats around the world thought about what was going on in Tunisia and Saudi Arabia and so on? Yeah, it's hard to draw a principled line between those two and say, because the Pentagon Papers case was about our government's wrongdoing, that's protected, its publication is protected, whereas what our diplomats thought what was going on in Saudi Arabia, they're urging us to bomb Iran. And that's not a public concern. Hard to draw that line. Mark?
I mean, the mere fact that when WikiLeaks they do every prosecution, espionage, there's this, the wiretapping, you feel that this may have some sort of, the fact that the magnitude is bigger, and there's also regulated at the highest government, like low level. This may have some, may have some, look at. I still don't feel like WikiLeaks don't use it the way with.
Yeah, there is a parallel between WikiLeaks and this, in that in WikiLeaks somebody acted illegally, probably Brad Manning. He, betrayed his trust, acted illegally, delivering the materials to WikiLeaks. But WikiLeaks isn't WikiLeaks in the same shoes as the radio station and the newspaper in Bartnicki. All they didn't do anything illegally. They get the information, they publish it. And if it's a legitimate public concern, that ought to be relevant to their First Amendment protection. Also relevant would be whether there's any harm caused by the disclosures, and the government hasn't yet pointed to any harm from WikiLeaks disclosures. Tina?
I was going to pretty much say what you said about. I think this is important because it shifts, for me, I think it shifts a lot of the burden to the acquisition of the information and the value of that versus the actual publication of it. Because, in cases where you're not looking at how someone's getting information, or if it was information that maybe isn't as sensitive, we often don't question the source that's reported. And so I wonder if the publication, should we jeopardize or should the publication censor themselves because they have to receive it? We should potentially question the sources totally.
And how do you answer that? Should they censor themselves?
I mean, I'm tempted to say no.
Somebody's acted wrongly here, and therefore we should hush this up.
I don't think so. I think that the publication, if they've seen it a public concern, has a right to release that information. And then I think the next step would be uncovering the source of the information. If that was a legal action, potentially going after the person who provided the information, how they did that, but not necessarily the publication. So I would potentially agree.
Yep.
Not just the right, but responsibility.
Like a duty? You mean they have a duty to get this information out? In the sense that somebody can sue them or prosecute them if they don't publish? I mean, usually violation of a duty means that. You're talking about a real duty. You're talking about a moral duty or an editorial ethical duty or something. Yeah, okay, Rob.
The problem I have with prosecuting somebody who's essentially a whistleblower is exactly that, is that there are consequences for whistleblowers, certain consequences for their actions, for sharing or publicizing or helping to publicize information that is a public concern, that is not necessarily good for the organization that comes being called out.
Yeah,
In the case of Brad Manning, he is a military. There are different rules that are used today, and we do this frequently to recognize that people that are military members are in a special class of person whose rights aren't exactly protected by the rest. So in a situation like, in the Pentagon Papers case, somebody who's not in jail, even though they are technically but that actually was a government employee.
At the moment of the leak, he was not a government employee.
Right.
So you say there's some...
The problem that I have with prosecuting people
Is what?
is
That's right. That's the government's point. We prosecute leakers in order to deter leaks. We prosecute whistleblowers who illegally disclose government secrets.
Right, but so long as those leaks are of no concern and don't cause any imminent threat or harm, then I think that the history shows that the Supreme Court gives a precedent that people shouldn't be prosecuted.
Well, that's a good argument. I don't think the courts I know that the courts have not gone that far and taken that step and say whistleblowers are protected in general. There are some specific statutes that protect whistleblowers in certain situations, but across the board, that somebody who illegally, unlawfully discloses government information is protected unless there's a showing of harm. The courts haven't gone that far. Let's turn back the clock or whatever it is to the Schulman situation and look at the second privacy tort that was involved in that case, intrusion, which doesn't necessarily involve publication, but it addresses the acquisition of information. I mean, you can't have much free speech if you don't have a right to acquire the information in order to speak. And that second tort of intrusion is illustrated by paparazzi, for example. He tracked celebrities around. Ron Galella is the tabloid photographer whose specialty was Jacqueline Kennedy, and he tracked her wherever she went after the president's death, and she lived in New York, and they had these little kids, and they'd be taken for a walk out in Central Park, and Ron Galella would pop out of a bush and take pictures of them and ambush them in that way, tracked her wherever she was. He's an incredible nuisance. And she brought a lawsuit against him for intrusion and won. And one of the outcomes of the litigation was that she got an injunction against doing what he did. Wait, is that a prior restraint? Got a court order saying, don't do that. Catherine? Am I asking? Yes. Mm-hmm. What his pattern is. Mm-hmm. You trailed off there. Are you saying that it is a prior restraint or not? So it's not a prior restraint. It was a prior restraint in near. I mean, I thought you were saying since he had the track record of 9 issues, it's just like Galella having a track record of following her around wherever she was, and therefore it's a prior restraint just like a near. But that's not what we're saying. Yeah. Right. You agree? It's different because what? What difference should that make? The person, the subject of the court order is the photographer, as opposed to the tabloids that he sells the pictures to. What difference should that make? I mean, he's the one who's following her around. And freelances for the tabloids, same. It's conduct, right? It's conduct, not speech, that's being enjoined. And this isn't expressive conduct. This isn't symbolic speech. This is pure conduct, and therefore would not be considered a prior restraint on speech. Galella also had some action with Marlon Brando, was another of his favorite. He armed himself with a helmet so that he wouldn't get hit by Brando or any of his bodyguards. But going back to the Schulman situation, she makes 2 claims. One, we've considered the publication of private facts, and second one was intrusion. And that has 2 elements. Intrusion into a place, conversation, or matter, the court says, in which the plaintiff has a reasonable expectation of privacy. And then second, the intrusion is done in a manner that is highly offensive to a reasonable person, same language used in the other tort, considering, and this is new and a nuanced interpretation of the intrusion tort, new with the Schulman decision, that you ought to consider in deciding whether it's highly offensive to a reasonable person, the motive for the intrusion as well as the method of intrusion. And so the court looks at what happened with regard to the televising of Ruth Schulman's automobile accident and its aftermath, and said that 2 aspects of the press's conduct there give rise to a claim for intrusion into a place or matter in which she has a reasonable expectation of privacy. One of them is they're shooting in the helicopter, in what is essentially the ambulance on the way to the hospital. That's certainly a place where one would reasonably expect privacy, certainly from shooting for television purposes. And second, and this is a little troubling, the court says that in her conversations with the nurse, Laura Carnahan, she could have a reasonable expectation that those conversations would be private, in much the same way that you would assume that conversations with your doctor or to any medical care giver would be confidential. Which seems right. You would have a reasonable expectation of privacy there, except that, remember what the court said was newsworthy when it was considering the publication tort. It said that the conversations between Schulman and the nurse were newsworthy because they showed the public the stress, the trauma, the difficulties under which EMT personnel have to work. So isn't there some logical tension between treating those as newsworthy in one breath and in the next breath saying, oh, but the person had a reasonable expectation of privacy in those conversations when considering the intrusion tort? Well, the court, for right or wrong, decided that she had a reasonable expectation of privacy in those conversations as well as in the ambulance. And then the question is the intrusion done in a manner that's highly offensive to a reasonable person? And you've got to look to the motive of the intruder. And here, that's a good motive, getting the news. The press is out there doing its job, reporting to the public what's going on. That's a noble motive. compared to what you can imagine ignoble motives might be, trying to get dirt on somebody for extortion purposes, tracking your boyfriend's whereabouts by video surveillance and so on in order to do something not nice. There can be bad motives, but here, where the press is trying to get a story, that may not be highly offensive, whereas other intrusions might be. Although the court says that there was nothing particularly intrusive about what the press did here. It's not like they did really tight shots of her face in her agony and so on, and sensationalized it. They already said that. But then what about the manner of the intrusion? And the court says, well, the press has got to have some leeway there, too. For example, if there were a prohibition on asking questions, routine news gathering methods like asking questions, that manner of news gathering, that manner of intruding into somebody's zone of privacy, could not be considered highly offensive. Whereas using a 400-millimeter lens snooping on somebody's bedroom from across the street, or fancy microphones or surveillance equipment, webcams, we'll come to that in a while, that manner of intrusion might well be considered highly offensive to a reasonable person. And the upshot is that the court decides that she's got a valid claim for intrusion. She didn't have for publication, but she does for intrusion, and the court says that the difference in the treatment between the two is largely a constitutional one. That the constitutional protection for news gathering, if any, is far narrower than the protection surrounding publication. It's speech versus conduct again. And speech is protected, conduct may not be. I mean, it's not like somebody passed a law that says you can't gather the news, you can't ask questions. It's not that situation at all. Kelly? Well, because the press always claims First Amendment protection for what they're doing, and they argued in Schulman that there is First Amendment protection not just for publication, but also for the process of news gathering. The conduct of news gathering has to have some First Amendment protection. If it doesn't, then they're not going to get the information to publish. No, that's correct, and the court's willing to grant that freedom. The court has said in several cases, without constitutional protection for news gathering, the right to publish could be eviscerated, the court says. Got it. And that's certainly true. Having said that, the court says, but the press, like all of us, is subject to laws of general application that affect all of us. I mean, the press, because it's the press, doesn't have an exemption from the tax laws or the labor laws or having to pay the minimum wage or any of those laws of general application. All of those laws impair to some degree the freedom of the press to do its job. Makes it costly and difficult to do its job. That doesn't mean that they have a First Amendment right to an exemption from laws of general application. And in the Schulman case, the court says, well, our law of intrusion is a law of general application. It doesn't single out the news media. It applies to everybody. And that means the news media got to comply with it too. But largely for constitutional reasons, the paths we have taken in analyzing these two privacy torts have diverged and led to different results. Somebody had a question about that? And then there was the Rutgers case from last year that's been in the news this week because of the verdict against Darun Ravi, the 18-year-old freshman at Rutgers, who I didn't follow in great detail the testimony in the trial. You may know it better than I, but just in general outline, what he did was figure out that his roommate, they've only been there 2 or 3 weeks at school, or beginning of the school year, figured out that his roommate was gay and that he had a lover coming over on a date to hang out in the dorm room. And so Ravi set up his webcam, pointed it at the bed, and retreated to his next door neighbor Molly Way's room, where he could watch the two make love. And he put up something on Twitter saying, you ought to see what I'm seeing. My roommate is kissing a dude. Yay, he says. And for our purposes, that's about all you need to know. But obviously what overshadowed the entire thing is that Tyler Clementi, the roommate, the violinist, jumped off the George Washington Bridge and committed suicide 2 days later after he had found out that his roommate was snooping on him. And the Ravi was criminally prosecuted under some crimes that I don't understand.